Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. We are on week 5. We're going to talk about design patents, the value, which is right for you, a design patent or a utility patent, the enforcing and defending against design patents. So we'll get right into this episode, which is regarding which is right for you, a design patent or a utility patent. Mark Getty said, intellectual property is the oil of the 21st century. In case you don't know who Mark Getty is, he's the founder of Getty Images, now the #1 supplier of images from media, corporate, and advertising images. So Mark's family, the Getty family, was in the oil business in the 20th century. The people who controlled oil were wealthy and powerful. So according to Mark Getty, in the 21st century, the people who control intellectual property are going to be powerful and rich. Intellectual property is a valuable asset for individuals and businesses, as it can provide a competitive advantage in the marketplace and generate revenue through licensing and other means. But without proper guidance, inventors may file for a utility patent when they need a design patent, or a design patent when they need a utility patent. So we're going to cover that today, help you get some basics on which one makes sense for your situation. Design patents protect the visual appearance or the aesthetics of a product. So if you think of the hood of a car, it's the way the hood looks. Now, in contrast, utility patents protect the function, a new feature or a new process. Now, a hood on a car, that's not new. It functions the same as basically any other hood. There wouldn't be any real significant difference between how one hood functions to another. And so the function is not what we're looking for in a design patent. It's how it looks. When you look at the design of your favorite car, whether that's a Corvette or a Lamborghini or a Tesla, you see the design of that car on the road and you know what it is, even if you can't see that symbol of that, whoever that manufacturer is. So that's where design patents come into play. And utility patents, that's how something functions. So for utility patents and design patents, there can be a lot of technical requirements. You're going to want to work with a skilled patent attorney. Design patents are simpler though, and they have a higher rate of making it through the patent office. They go through the patent office faster, and so generally they cost less, but they are definitely different than a utility patent. So if you need a utility, you don't want to file a design. If you need a design, you don't want to file a utility. So design patents also, they're only granted to a design embodied in a product. So you can't just say, here's a design and you could put it on anything. You actually have to show the design on what it's embodied in. For example, we can file a design patent for the unique layout of a website, or even just a portion of a graphical user interface. But to obtain that design patent, we must show it presented on the screen of a computer. So we put the computer screen in dotted outlines saying, well, this is the environment, the product we're showing it on. And that would be how we would get a design patent on an element of a graphical user interface, GUI. So as I said, a design patent covers the ornamental design, and it has to be embodied in some kind of product, something physical. And design patents can be quite a bit narrower than a utility patent, but there's a lot of cases where the utility patent, you're not going to get strong coverage because the function has been done before, or something very similar has been done before. And where your real innovation is in the design, in how it looks, what makes it attractive. And it says specifically in the laws for design patents that they do not cover functional aspects. So if you have a design patent and you show it embodied, you got a new mousetrap. Nobody's ever thought of a mousetrap like this, and it's incredible. And so you file the design patent. Well, as long as somebody doesn't have if they can copy it, as long as they don't copy the design, but they can copy the function, because it specifically does not cover the function. So design patents are especially useful in fashion, furniture, consumer electronics, where they design it to look cool. And then let me review real quick again, the utility patent, that is on functional features and methods. So for both of them, it has to be new, useful, and non-obvious. But the usefulness, for a design patent, it just has to be something embodied in something that's useful and legal. So the main difference, once again, is the design patent covers the way something looks. The utility patent covers the way it functions. Design patents the length of them is 15 years from the date that the design patent is granted. And usually so the average is about 20 months from filing to grant on a design patent. So a little under 2 years. And for a utility patent application, it's 20 years from the date of filing, but the average is about 30 months, 2.5 years, to get the patent granted. So you're expecting about 17.5 years for protection for a utility patent application, 15 years for a design patent application. So one of the questions is, can you get both a patent on the design and the utility for the same product? So the answer is yes. Of course, if you've got something that nobody's ever seen before, then you want to clearly differentiate what part of this is just the aesthetic design and what part of it is the function, so that it's clear what your patent covers. And one of the things that's happened, and I've seen this, where inventors come to me after they've worked with somebody that didn't give them good advice. They said, oh, well, a design patent is cheaper, so let's go that direction. When what they really needed was to cover the function. And if what it is that's unique is not really seen on the outside of your invention, then you're not going to cover that in a design patent. If it's on the inside, if it's hidden, and the consumer doesn't really see it, even though it gives them the function they want, that you're going to need a utility patent application to cover. But if when they look at it, it's a new design, then it definitely, design patent can cover that. And of course, if you got both, you can file both. The one other difference between the utility and the design patent applications is once a design patent application is granted, there's no renewals needed. With a utility patent application, there's a renewal that needs to be filed around 3 years, 7 years, and 11 years after the patent is granted, or it will go abandoned. So you're going to want to discuss your business goals and plans with a skilled advisor to determine how patents give your company a competitive advantage. And understanding the different ways you can protect yourself is very valuable. And so we always start with strategy. What is your strategy? How does it fit into your overall business strategy? And with a design patent, we still recommend a comprehensive patent search. Sometimes we do a patent search and we're actually going to look at, is this going to be protected? Is the function available for patent? And if not, we're going to focus on the design. So sometimes the patent research tells us which direction we're going to focus on. And of course, to get a design patent, you have to file a patent application in the United States Patent and Trademark Office. One other thing about design patents is they are not published until they're granted. They don't have a publication like utility patent applications. When you file a utility patent application, the default is it gets published 18 months after you file it, unless you ask them not to. If you want international coverage for your design patent, you need to file that within 6 months of filing your original application in the US. You'll need to file it into other countries. So if you have a product that, or an invention you believe may be eligible for patent protection, call me. Let's have a consultation about it. I do a free consultation for the initial meeting, and you gotta make sure you don't disclose it before you use it. That's still true for design patents as well. If you have started selling it, you want to get a patent filed as quickly as possible if that's the right direction for you. So we're out of time. In our next episode, we're going to discuss the value of a design patent. I'm Wayne Carroll with Leveraging Inspiration.